look at selling some other assets and change your lifestyle, because it's got your first priority is child support. There's about $180,000 some dollars due to Ms. Sourds, and nothing's been paid on those obligations as of this date. Is that correct? For the record, this matter is before the court to review all outstanding issues, primarily the sale of real estate on West Newburgh Road. This hearing is being conducted via Zoom. Present is Attorney Maria Gorski, representing the plaintiff Ashley Sourds, and Ms. Sourds is present. In addition, Attorney James Petrangelo is present, and the defendant Adam Sourds is present personally here in court as directed by this court for possible contempt proceedings. The parties have conferred this morning with Ms. Laprade from the front of the court. There's nothing in the court's queue yet, Ms. Laprade.
Yes, sir. Your Honor, there is going to end up being 3 different recommendations that are going to be in the queue. One is going to be a motion rec, one is going to be a de novo, and then after we complete the show cause, I will upload a show cause order for you to sign.
Okay.
They should be in your queue now. I apologize.
Yes, one is now in the queue. Noting that the home has been listed for sale, presumably that is 6253 West Newburgh. Is that correct, Mr. Petrangelo?
It is, Your Honor.
And the other parcel had been previously listed, correct?
No, the other is not listed. The other is basically mortgaged to the point there'd be nothing generated. I did provide a report from the realtor to Ms. Laprade and Ms. Gorski. I can briefly recap for you as to the situation.
It's also noted, I'm sorry, Mr. Petrangelo, that Mr. Sourds shall accept, it's recommended that he shall accept the offer that's been received. So in other words, home has been listed, it's been added to the multi-list, and he's already received an offer. Is that correct? Is he inclined to accept that offer?
His realtor has another open house. He had one last weekend, and he has another one scheduled for this Sunday. The issue with this offer is it's a very low down payment with a closing by September 30th. And so he's doesn't appear as the strongest candidate to get through. It doesn't mean he won't. For that reason, the realtor he said at the last open house, he had 10 buyers come through, most with agents. He said the best bet for everybody to get this done, and I spoke to him, heard him over the phone too. He would recommend he be allowed to have the open house on Sunday and give Mr. Sourds until Tuesday to accept the best offer. He said, however, if this buyer is going to bolt, I'll tell him, and he can accept this at that time. So that's our situation. His report goes on to talk about all the work he did to get this in a marketable state, and that he said he's done an excellent job. And so we have a lot of interest, and it's actively being worked on. And the offer, if it goes through, will take care of everything and then some. It's just obviously if somebody comes in with 20% down or some stronger ability, we know that Ms. Sourds is going to be more certain that she's going to get her money.
This is a cash offer though, correct?
No. His offer is contingent on him being able to get a new mortgage with a 3% down payment. At least that's the way I read it. I did forward that offer as well.
When does the offer expire?
It does not, in my reading, contain an expiration date. And it was made just this week. So I don't, in my reading, I don't see a date that says it expires at a particular time. The realtor's in communication with this other realtor, as the buyer has limited resources to push this too much. I just would hate to, in real estate, what could happen, this guy doesn't get his mortgage and can't close, and then we're trying to move to somebody else. I think if the realtor, it sounds like he's describing a very active situation, a few days to accept seems reasonable and most designed to make sure Ms. Sourds gets her money. I think under this offer, it's to be closed by September 30th. I'm going to ask that the court consider with any other requirements you have, that we put this over until after that date.
There's an open house this weekend.
Yes, June 1st.
Okay.
And I believe that shows up on one of the Zillow or other listings as well. I saw that yesterday when I was checking the sites.
Just wondering if the realtor can market this as give us your highest and best offer. Market in that, frame that, so people know that if they are interested, they need to do their offer, make their best offer on September 1st or that day.
And I told him, if you give him a few days, it's going to be, Mr. Sourds is going to have to accept any offer on the table at that point. And so he's got these people, as I said, he's put in writing that he had that many people going through and interested. It does seem like work is going on here to actively try to get this quickly sold.
Right. And we were last before the requirements were changed on August 7th. Is that correct?
Yes.
It took Mr. Sourds, 19 days to sign a listing agreement?
No. Apparently, and part of this letter is, for lack of a better word, there was more or less a junkyard going on the property and the outback areas and disrepairs. And frankly, the realtor said to him, if you want to sell this, you got to get this stuff out before I post any pictures. And so his letter says, the property held significant personal content, which he's been working to clear out, including large vehicles, storage trailers, business inventory. Based on the timeline, he's done an excellent job of clearing those out, removing items in the yard to prepare for photos. There was a large amount of work required to get the property market ready. He also worked through a significant list of primarily minor cosmetic repairs to the property, repairing siding, updating flooring, organizing, and cleaning. So then professional photos and drone shots were completed on Saturday, August 24th, and added to the MLS. So I think this realtor knows he's got a segment that's interested in this kind of property, and he's trying to make it as marketable as possible.
Right, thank you. Mr. Gorski.
Yeah, Judge, first and foremost, my client doesn't have any obligation to maximize the profit to Mr. Sourds. Mr. Sourds has an obligation now that is months overdue. So he's had an offer, and we think it should be accepted. Mr. Sourds, this was a 10-acre parcel that my client quitclaimed to him pursuant to their judgment. Mr. Sourds has taken it upon himself to make this a 2.68-acre parcel. He had it resurveyed, and what he is selling is less than what my client gave him for this settlement, for which he has not paid. He's keeping the pond. He took the pond off of the property, and my client does not believe that there were significant amounts of items outdoors. She will acknowledge that there were a lot of things indoors, which the photos appear to show that he has removed. But this went on the MLS 2 days ago. 2 days ago. And he immediately got an offer, and we think it should be accepted so that my client can be paid.
Right, the court obviously has been informed that the current offer does not have an expiration as to a time frame. So the court does not see any harm to anyone to give Mr. Sourds an opportunity to conduct this open house scheduled for September 1st. It's right around the corner, and we can come back and review this. And if he's not received a better offer by then the court's inclined to order that he accept this offer when we come back. So the court's inclined to put this over for a week. Perhaps let's see if we have time for available on Wednesday of next week.
I can be available.
Courts is nothing available on Wednesday, perhaps on Thursday.
I have Thursday morning, I'm available.
Right. Ms. Nancy, do we have someone Thursday morning?
I'm in mediation with Ms. LaPrade, but I can step out, I guess, for a minute.
Okay. I'm sorry, the court has a full day trial on September 5, that Thursday. We have 3:30 on September 4th. I'm sorry, 3:30. How about Tuesday, September 3rd at 2 o'clock? Is everyone available?
I'm available.
I'll make it work.
All right. The court will At this point in time, the court will reserve any decision on the current offer, and the court will simply adjourn this matter to September 3rd at 2 p.m. So, Mr. President, if you could just revise your recommendation in that regard.
Yes, sir.
And then finally, and then perhaps the realtor, and I don't know if you have contact with the realtor, or Mr. Sourds is here, he can communicate with the realtor. She needs to market this as give us your final and best offer, because we're going to accept an offer next week. So sometimes I know some communities, like real estate areas like Royal Oak, those realtors market the property as give us your final and best offer by a specific date. Maybe that they provide that by Monday, 5 o'clock or something, or Tuesday morning before we come back to court, final and best offer. That's his court suggestion. I'll leave that to you, Mr. Petrangelo, and Mr. Sourds, to relay that to the realtor, that suggestion. With respect to the other issues, the courts received a de novo order that the referee recommended order be rescinded and canceled for an enforcement order dated August 28th, 2024. Mr. LaPrade, that had to do with child support. Is that correct?
That is correct, Your Honor. It is it was before referee McKee. He requested to adjourn the matter or recommended to adjourn the matter to August 7th. That date has passed, so we are requesting to rescind, but we would like to proceed with the show cause.
With contempt, is that correct?
That is correct, Your Honor.
What are the current support arrearages?
Current arrears balance is $14,629.50.
Right. What was the last payment made by Mr. Sourds?
Mr. Sourds made a payment yesterday of $1,800. That payment has not dispersed yet, but that payment was made. This has been pending for quite a while. Referee McKee recommended the adjournment for the home to be listed. As we know, that has been delayed as well. There were no payments made during the month of July. Mr. Sourds did state he did have income in the month of July. He didn't have an exact dollar figure, but friend of the court is requesting we proceed with contempt.
Thank you. The $800 that was made online, is that correct?
It was made here at the window. It just takes a day to disperse, Your Honor.
Okay, what was that? What is the cash payment though, correct?
That is correct.
Right,
But that's not included in that arrears balance, Your Honor. That
Right.
was an August payment.
The court's aware that an online payment can be revoked.
That's
So
correct.
I just verify it's a cash payment.
Yes, sir.
Mr. Petrangelo, have you an opportunity to discuss with Mr. Sourds contempt proceedings?
Yes, Your Honor. What I would tell you, first of all, is that 1,800 plus the amount he paid early in the month of another 700 that he made a full month's support payment this month. Of course, that's not July, that's August, but my client is very mindful of the fact he's overdue in this obligation and of Ms. Sourds and the children's needs. He very much is. He asked that the court consider in determining his ability in this situation. He had all of the expenses to get this property on the market to sell. He also, in the past few months, has had numerous debts, including, he said it's about $12,000 in taxes, I think is a new thing, or a number he threw out, including property taxes on this earlier this summer, to make sure this did not go on tax sale. And so the money he's been scrambling to cover all of these things to make sure this property is available and marketed. And as one other thing, which isn't normally a factor, we had negotiated quite some time ago for, in the end, 6 children to be flown here for the month of July. And that was their first visit with Dad in 3 years. And as part of that, Mom had a list of or some things she wanted to be sure were taken care of before they stayed in the house. So he's had a lot he's scrambling around to put together. It doesn't delete the amount due and the need, but it also shows he's not just sitting around blowing all this off. This man is hustling, trying to get us across the finish line right now. I'd ask you to consider delaying or reserving a decision on this at this time.
Thank you. Obviously, if Mr. Sowards cannot afford the child support order, he's got to file a motion to reduce his support obligation. He just can't sit on his hands. The court would also note that the Attorney General generally gets cases in which the arrearages exceed $10,000 catch the attention of the State Attorney General, and they'll charge him with a felony charge of felony non-support. So what the court would like to do is secure a contempt finding today, but the court's inclined to reserve sentencing on that contempt. In other words, Mr. Sowards would be holding that key to jail, and if he does not address this obligation in a timely fashion, then he'll be putting himself in jail. So with that, the court's position on that, Mr. Petrangelo, does he want to present some testimony this morning from the front of the court, or is he willing to admit to contempt?
Your Honor, I believe my client would just not contest the finding at this point because of the amount, not the work he's been doing recently.
Mr. Sowards, you understand that if you're found in contempt for failure to comply with an order of this court regarding child support, you could be ordered to serve up to 45 days in jail. Okay, you've discussed all these matters with Mr. Petrangelo, is that correct? And are you willing to admit to contempt this morning? The court is inclined to reserve sentencing, which means you have 45 days hand over your head, and you're going to hold the key to that jail. All right, raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God? Please state your name for the record. Mr. Sourds, do you admit and acknowledge that you're obligated to pay child support for the support and maintenance of the children born to you and Ashley Sourds? Admit and acknowledge that prior to yesterday's payment of $1,800, you had arrearages in excess of $14,000. Admit and acknowledge you paid nothing, not even $1 in the month of July of 2024. Mr. Petrangelo, do you have any questions, Mr. Sourds?
Under these circumstances, I don't, Your Honor.
Right. Ms. Gorski, do you have any questions, Mr. Sourds, regarding the contempt finding?
No, thank you, Judge.
Ms. LaPrade, do you have any questions, Mr. Sourds?
No, I do not at this time, Your Honor.
Well, based upon the testimony of Mr. Sourds, as well as a review of the records contained in the court file, the court finds Mr. Sourds being contempt of court for failure to pay child support as ordered. The court, however, will reserve sentencing in that contempt. Actually, the court will order that he serve 45 days jail, but that 45 days sentence is reserved at this time, Mr. Sourds. You got 45 days hand over your head, so you're on a fine line to spend some time in jail. If you do not take care of this obligation, you need to look at selling some other assets and change your lifestyle, because it's got your first priority is child support once you pay the sums due to Miss Sourds. There's about $180,000 some dollars due to Miss Sourds, and nothing's been paid on those obligations as of this date. Is that correct?
Judge, the amount owed for the property settlement is $108,920.59. He also owes over $14,600 in child support, and that amount does include the $1,800 he paid yesterday. Until yesterday, it was over $16,000.
The property settlement's about $108,000.
Yes.
Yes.
Okay.
There's another $80,000, but that's not due until 2027.
18,000 for the business portion, I believe.
That's included. That was supposed to be paid in March.
All right. So as of the date, it's about $108,700 some dollars due for the property settlement. Is that correct? And hopefully
Yes.
that can be paid out of the sale of the proceeds from the real estate.
Yes.
Yeah.
That will certainly assist. So, Mr. LaPrade, perhaps to the rec, you can just simply add that Mr. Sowards is found in contempt. 45-day sentence is reserved at this point in time, and the matter will be adjourned.
Your Honor, front of the court would request we move this to Ms. Hicks' docket October 1st at 8 a.m. to make sure that September payment is made. That would be the request on the show cause.
Very well, so ordered.
Thank you, Your Honor.
We'll put this back in our docket for Tuesday, September 3rd at 2 o'clock. Anything further this morning, Mrs. Gorski or Mr. Petrangelo?
No,
No,
thank you.
Your Honor.
Right. All
Is
right. Thank you, Mr. Pratt, for your assistance this morning. I'm sorry. Go ahead.
your October 3rd is a Thursday. Is it?
October 1 is the show
October.
cause. September 3rd is to monitor the open house, Mr. Petrangelo,
Okay.
just to clarify those dates.
October 1 at 2 o'clock is the show cause docket.
October 1 at 8 a.m. And then Judge said September 3rd was 2 o'clock or 3 o'clock, Your Honor?
2 o'clock.
Thank you. Let me get that corrected for you. I thought I heard 3.
Okay, and all these things, I'm sorry, confusion. The October 1 is at, you say,
8 a.m. with Ms. Hicks.
A.M. Hicks. Okay, thank you.
Thank you.
And obviously, if Mr. Sourds has made payments between now and then, Ms. Hicks will not bring him before the court. If he's paid nothing, Ms. Six will probably bring before the court later that morning, Mr. Petrangelo, for us in
Understood.
jail. Okay, all right, that will conclude this hearing. We can zoom out. Mr. Swords, you're all set to go. Talk with the realtor and have the realtor make it clear to potential buyers that submit their final and best offers by Sunday or Monday, so that they know that you are a very interested seller. All right, that will conclude this, Mayor. We can zoom out.